Good morning and welcome to today's webinar, which is about climate change litigation and planning. So I'm Neil McLean, I'm a partner in the Government Regulation and Competition practice at Brodie's, and I spend a lot of time dealing with planning and environmental challenges. So this is an area I'm keenly interested in. I'm joined by Neil Collar, who's head of our planning practice, and Neil and I work together on a lot of planning challenges, and I'll let Neil maybe say a bit more about himself when he comes to speak. And similarly, we're joined by George, who's in our planning practice, and you'll see that George there has gone for a much more atmospheric photograph than Neil and I. We have an added complication today, of course, in that we have two speakers named Neil. So if you do have questions for one of us, please identify that in the Q&A box, and please be kind when you're distinguishing between the two of us. So that's who we are. By way of introduction, I just want to give you a look behind the scenes at how we plan webinars at Brodie's. So Neil Collar and I, as we often do, we're talking about planning challenges we were working on together, and the conversation turned to other recent challenges. And it struck us that more and more often, planning challenges have an environmental aspect, and that environmental aspect now increasingly involves a challenge linked to climate change. And so the idea for this webinar was born. With that in mind, the task we've set ourselves today is to explain what is climate litigation, what do we mean by that, to give an overview of some international developments, and then explain how they feed into trends in the UK. Our focus will then get a bit narrower, and Neil will explain what those trends mean for planning law in the UK. And finally, we'll look at some issues around EIA and what the courts have made of climate litigation and planning cases. So as you'll see, hopefully our aim is to start big. And by the end, we'll hopefully have demonstrated the relevance of climate litigation on decision makers, developers, planning consultants, or anyone else with an interest in the planning decision-making process. So starting then with what is climate litigation? Well, we've included on this slide quite a broad definition. It covers a range and types of legal proceedings that relate in some way to climate change and its effects. And it includes litigation before the courts, but also regulatory bodies and their tribunals. So it's important to stress that we're not just talking here about traditional courts. In many jurisdictions, there are specialist tribunals that deal with environmental issues. Not included for the purposes of the figures I'm about to mention, but it would equally include any complaints mechanism founded on environmental social governance principles. And I'll talk about those in a moment. Climate change litigation continues to grow in importance as a way of either advancing or delaying effective action on climate change. And annually, the London School of Economics produces a global report about climate change called Global Trends in Climate Change Litigation. And we're now on the third report on global trends. And what you can see when you look at that report is a huge geographical spread of cases. They have a map which, new colours are filled in every year as cases spread across the world. And that's reflected in the numbers. And you'll see on the slide that we explain that LSE has reported that globally the cumulative number of climate change related cases has more than doubled since 2015. Just over 800 cases were filed between 1986 and 2014, while over 1,000 cases have been brought in the last 6 years. So that's really quite a significant increase in the number of cases that have been brought. So what types of cases have been brought? So what we've done is we grouped these together into three groups. We've done that because they also really describe the types of climate litigation we've had in the UK, and which we also see is on the increase. So the first of those groups is actions against government, and we're describing this as strategic litigation. And the number of strategic cases is dramatically on the rise. And those are cases that aim to bring about some broader societal shift. So they're sometimes, but not always, linked to emissions targets, and in particular the Paris Agreement. They're typically brought by NGOs and environmental campaigners. And as I'll come on to say in a moment, there have been a run of successful challenges in the last 12 months. The second group is actions against decision makers. So that are challenges to both central and local government, and they tend to arise in planning cases, as we'll come on to talk about, and also in permitting decisions. And that's the most common and well-established type of challenge. And Neil and George will say about why that is shortly. And the final group is actions in the private sector. And that's distinct from the others because it's not about governments or decision makers. These are cases that target directly a wide variety of private sector and financial organizations, and there's more diversity in the arguments being used in those cases. And they've been helped by the rise of the need to report ESG obligations. So ESG obligations are environmental, social, and governance obligations, and I've listed some of those on the slide, one of which is an institution's approach to environmental protection. It's also now possible to use complaints processes to hold private sector companies to account, even if there's no litigation. So an example might be that you can complain to a large financial institution about the failure of a private company to adhere to ESG principles. Now that obviously still carries significant reputational risk, even if it's not litigation in a court or a tribunal. So moving on then to look at how is that playing out in practice, and starting in the international sphere. So I mentioned that there had been a run of successful cases a moment ago. It's not on the slide, but it starts with the successful challenge by the NGO, the Agenda Foundation, against the Netherlands in December 2019. And in that case, the Dutch Supreme Court ruled that the Dutch government had to reduce Dutch emissions by a minimum of 25% by 2020 compared with 1990 levels. And the reason it did that is that it found that the Dutch government's failure to take responsibility for the contribution to the climate crisis was a breach of its obligations under human rights law. And that was really quite groundbreaking at the time, because what you had was a group of individuals and an NGO relying on human rights law in order to hold the state to account for climate change. And that was followed in February 2021 by a challenge brought in Germany to the German Federal Climate Change Act. And again, a similar argument was made in that case that the act was incompatible with constitutional rights on emissions, and so prejudiced future generations because the German government was failing to take precautionary steps, and what the act was doing was offloading major emission reduction burdens onto periods after 2013. And this is interesting because it's an example of what's sometimes described as intergenerational litigation. So the younger generation litigating because they say they will be the ones that have to bear the burden of climate change if emissions targets are pushed back beyond 2030. So Germany has complied with the court's ruling and has brought forward new legislation to deal with the issues the court identified. And that was followed in July 2021 by a similar challenge in Belgium, where again, an NGO combined with Belgian citizens filed an action against the Belgian state for Belgium's failure to take sufficient action in relation to reducing emissions. And similar to the Dutch and German challenge, an argument was made that not only breached Belgian law, but also breached human rights law. And again, the court in Belgium found that there had been a breach of human rights law. However, they declined to actually make an order mandating a reduction in emissions targets for reasons to do with the constitutional setup in Belgium. And there's been a similar decision in Ireland in July 2021 with the Irish Supreme Court finding that its government's national mitigation plan for climate change exceeded the government's powers because it lacked specificity in terms of what the Irish government were actually going to do. And it was described by the court as being excessively vague or aspirational. And I could continue talking about actions in Brazil, Canada, France, and elsewhere, all which raise similar types of challenge. But I want to move on just to talk about that third category, which is actions in the private sector, because there were some really interesting things happening here. Recently, there was a potentially quite significant challenge brought by several NGOs, including Friends of the Earth, against Shell. So this is a private action raised against Shell, not an action raised against the government. And the NGOs claimed in that court case that Shell had to reduce its overall CO2 emissions by at least 45% from 2019 levels by the end of 2030. And they did that based on various policy statements Shell had made in its company documents, and an indication that Shell was going to fail to reach those targets. The Dutch court ruled in favour of the NGOs and ordered Shell to reach the target reduction, so a court order that needed to be complied with. And it's the first time that we're aware of that a court has ordered a company to reduce its CO2 emissions in line with the climate goals included in the Paris Agreement. Of course, in arguing against the case, Shell made the point that the Paris Agreement is something that binds states, not companies, and that compliance with those targets had to be dealt with at a state level, and that Shell could not be responsible for managing the emissions targets that come out of the agreement. The court's decision is based partly on Dutch law and a provision in its civil code, but also the court took into account international frameworks like the UN's guiding principles, and also, again, human rights law. And looked at all of the facts and circumstances, including the consequence of Shell's CO2 emissions, but also, importantly, Shell's influence over CO2 emissions in its group and in its supply chain. Shell was found to have an obligation of result, as it was described by the court, for the activities of the Shell group, and that meant that Shell had to ensure that its group of companies reached the target reduction figures, but also an obligation which was described as significant best efforts obligation with respect to its business partners, including end users. So that involves Shell taking necessary steps to remove or prevent the serious risk resulting from CO2 emissions generated by Shell's business partners, and Shell using its influence to limit the lasting consequences of those emissions. So likely to be the last word on this case. Shell announced in a press statement after the decision that it will appeal. But there is quite a nice quote that comes out of the decision. If we move on, you'll see that on the next slide, in which the court acknowledges, of course, that Shell can't solve this global problem on its own, but it has a part to play in and responsibility for reducing emissions in the Shell group and those which it can control and influence. And it will be interesting to see what happens if that decision is appealed, or whether a similar sort of challenge succeeds in another jurisdiction. I'll just pause there to say that I'm mentioning these decisions because we have similar challenges in the UK, and we're only likely to see more challenges of this nature, including as new targets are set by governments and by private sector companies in their own policy documents. So I'll now move on to the UK and the strategic challenges we've seen there. In the UK, there was a challenge in June 2021 which failed, and it was a challenge brought by an environmental campaigner, Georgia Elliott Smith, to the UK emissions trading scheme, which is a scheme that was set up to replace the EU scheme. And she argued that an initial cap of 156 million tonnes of CO2 was considerably above the amount expected to be emitted by the sectors concerned. And that was incompatible with short and medium-term obligations in the Paris Agreement. So that's a strategic piece of litigation against the UK government and its compliance with Paris. But the court followed well-established principles to find that the Paris Agreement is an unincorporated international treaty, and it was not the UK court's role to resolve questions of the construction of the agreement. And that effectively the approach taken by the relevant government department was appropriate because it recognised the need to address climate change and the need to have measures in the short to medium term as part of that, but really left it to the government's discretion as to how best to implement those measures. And there was also, as you see in a lot of these challenges, a recognition from the court that it was not appropriate for the court to go behind detailed technical scientific modelling that had been carried out, particularly where no rival modelling or criticisms of that modelling work had been advanced by the challengers. So the court found that the UK government had complied and the challenge failed. I am conscious of time, but I just want to move on to talk about 3 other challenges which are of interest, really to emphasise the point, if I've not already, that there is an increasing number of these types of cases going through the courts. The next challenge we're likely to see is one that's brought by Plan B and 3 young people, which is a judicial review again against the United Kingdom government about its failure to comply with the Paris Agreement. And this is a challenge that raises directly human rights arguments, similar to what we've seen in other jurisdictions in the cases I've talked about a moment ago. So it would be quite a novel challenge. And in the claim form which has been published, you see Plan B and the challengers talking about the UK government continuing to support the opening of a new coal mine, financing overseas fossil fuels projects, and also reducing financial support for international communities already exposed to climate change. So a wide range of arguments about the UK government's failure. Perhaps more traditionally is the Greenpeace challenge to the consent given to BP for the development and production from the Vorlich oil field. That was a challenge heard in Scotland this month. Greenpeace is arguing that on quite traditional grounds that when the drilling permit was granted, the UK government failed to carry out an appropriate environmental impact assessment. But the novel point that's been raised in this case is that that environmental impact assessment should also have assessed the cumulative environmental impacts, which include emissions resulting from the burning of the fossil fuels extracted. The government's response to that is that there's no legal duty to consider indirect impacts. And finally, the case described as the Paid to Pollute case, which again is strategic litigation and is a judicial review of the Oil and Gas Authority's new strategy, which was laid before Parliament in December 2020. And that gives the Oil and Gas Authority a mandate to secure maximum value of recoverable petroleum from within relevant UK waters. And the argument in that case is that that plan is irrational and inconsistent with the UK government's net zero target, because it will lead to more oil and gas being extracted than would otherwise be the case. Permission for that challenge to go ahead has been granted. So what conclusions do I take from all of that? Well, we see strategic litigation being brought internationally and that being replicated in the UK, including across all 3 different types of climate change litigation I've talked about. The number of cases being brought by environmental campaigners is on the rise, and there have been some notable successes in the last year, although we're still waiting for a successful UK challenge on pure climate change grounds. So I'm now going to hand over to Neil Collar, who is going to say a bit about what that means for planning.
Right, thanks, Neil. And I suppose to pick up Neil's invitation from earlier on to introduce myself, I'm the head of the planning law team at Brodie's, hence me talking about my favourite subject of planning. And as Neil said, the background to this webinar was very much just us throwing around thoughts and identifying that so often the planning system, planning cases get involved in these wider campaigning issues. And I thought it would be useful to touch on some of the reasons for that. And then what I'm going to do is pass over to George, who's going to look at some of the cases. So this slide sets out my explanation for why the planning system becomes the focus. The first bullet point there, planning permission is required for pretty much anything of any substance. And that means the planning system is engaged. More importantly, it tends to be the first of the environmental permits that is applied for. That's because it is such a broad discretionary system. That is the most risky consent. The others tend to go through a much more technical scientific process, so the outcome is more predictable. So you apply for planning permission first, and it's only once you've got the permission that you then go and do the very detailed work for getting the more scientific-based consents. Planning system is very open to public participation. Yes, members of the public who participate often complain it's not working for them, but the procedures, there's lots of notices, publicity, and quite often decisions are made by local councillors who are open to discussions with their constituents and whatnot. Planning decision-making takes into account government policy. That's a standard thing. So government policies on climate change are engaged. The bullet point I've got there about politicians often giving more weight to economic benefits than environmental impacts. What I'm getting at there is the controversy, if you like. We have seen it over recent months with the coal mine proposal in the north of England, where there's a lot of umming and ahhing at the moment about whether we should be giving planning permission to a new coal mine, given that we're in a climate emergency situation. Inevitably, there are a lot of economic benefits, which is why politicians, the Westminster government, are swithering about how to approach it. A more historic example, but just to illustrate what can happen, the M74 Northern Extension in Glasgow went through a public inquiry. Scottish Government official then gave the recommendation to the ministers. That official recommended refusal on the basis of environmental impact, air quality and the like. But the Scottish ministers decided that the balance tipped more in favour of the economic developments. They consented it, it was built. It's been there for many years now. So that's the example of why climate change can become a bone of contention in planning decisions, because there are economic benefits which can perhaps be given more weight than the environmental impacts. So to environmental campaigners, that results in the wrong decision, as it were, the decision they don't like, which then means that they want to challenge that. Planning decisions are subject to the well-developed principles of judicial review. And then finally, the Human Rights Act applies. So that brings in a potential to argue impact on the human rights of the individual. So you can see, hopefully, from those series of bullet points, how it creates the right atmosphere, as it were, of people being able to engage in the process, but equally that process not guaranteeing a climate emergency friendly, which feels like a very wrong way of putting it, but I think you can see what I mean, outcome and then potentially litigation. And just to touch on the planning system recognising climate change, and George will get into this in a bit more detail. I've just set out here some of the legal background. The planning system is a mixture of development plans and material considerations. On the left-hand side, I've set out, it's Scotland specific. There's broadly similar stuff in England, and George will touch on that. In Scotland, we have a new statutory purpose, anything which contributes to sustainable development, and the Scottish Government's National Planning Framework 4, which will be approved next year. That is to be part of the development plan. So for the first time, the Scottish Government policies, including their response to the climate emergency, will be part of the development plan. So it will be a key part of the planning decision-making framework. The other part of the decision-making equation, if you like, material considerations, that's always included environmental effects. I've mentioned their environmental impact assessment reports. George is going to speak about that. Equally, transportation impacts have always been part of planning decision-making. So in that sense, climate change is an issue, the climate emergency, although it is creating a very different emphasis, it is really building on the principles and the factors that the planning system took into account anyway. So it's a change of emphasis rather than a fundamental change, and very much an evolution, and maybe not even a particularly significant evolution. It's maybe just a sort of slight change of emphasis in how planning deals with things. And to complete the picture, I thought it was worth just touching on how planning decisions are made, because it does explain in part why climate change litigation may arise in the planning sphere, but also why, as George will go on to look at in more detail, the cases are difficult to win. Planning law is very much a balancing exercise, hence the picture. And so far, there is nothing in the law or government policy which says that that climate change should trump other planning considerations. So it's back to my bullet point in the previous slide about economic factors. In principle, economic factors have the similar weight to the climate emergency. It's up to the decision maker in the individual case to weigh up and decide, am I going to give more weight to the climate emergency? Am I going to give more weight to economic considerations? That may change in time, but that's the current situation. There is no third-party right of appeal. So if you object to a planning application and the permission is granted, you cannot continue the argument on the merits. Your only remedy is to go to court, judicial review, and argue it on legal grounds. And looking at those legal grounds, this balancing exercise, a lot of it is about exercise of judgment, and that exercise of judgment is only challengeable if it's perverse or irrational. And it's quite important to just focus on that perverse, irrational. That really expresses the judge's reluctance to get stuck in. It has got to be really exceptionally wrong, not just wrong. And again, an issue that George will be touching on, international treaties, Neil mentioned some of them, Paris, etc., aren't directly relevant unless they're referred to in an act. And that was an issue, part of the arguments in the Heathrow and the Drax cases that George is going to come on and mention. So if we move on to the next slide, and in fact, it is George. So I'll just pass over to George. As Neil said, another member of our planning and environmental team, and quite importantly, given the cases he's going to come on and talk about, George is English law qualified. So it's very apt that he's going to go on in a few slides' time and look at some of the English case law. George.
Thanks, Neil. So I'm initially going to look at kind of environmental impact assessments and the regulations. So where an EIA is required, local authority can't grant planning permission without first taking into account relevant environmental information. Such environmental information is set out in Schedule 4 of the EIA regs. obviously, Schedule 4 information is broader than just climate change and greenhouse gas emissions, but there's some obviously that touch on these points. Some are listed on that slide. I won't read them all out, but one that was interesting, I suppose, is that final point, which is the vulnerability of the project to climate change. So it shows there's an element of what impact is your project going to have on climate change, but also kind of vice versa. How might your project be impacted, and how that might impact your impact. Schedule 4 requires you to look at direct and indirect effects, secondary effects, transboundary, short-term, long-term, as well as the accumulation of effects between your project and existing or approved projects. So that's kind of the background of what information you need to include. So moving on, kind of one of the elements you need to include is a greenhouse gas assessment. And so this looks at the net greenhouse gas emissions for a project through its lifetime, so construction, operation, decommissioning, and also looks at the current environment and the current the use on the land. So in that, on the slide is the Space Hub in Sutherland, and that kind of the carbon assessment. It looks at kind of the greenhouse gas emissions from construction, but also kind of great gains around restoration of peat. If you look at, say, a housing development, let's say it's on agricultural land, the agricultural land use is quite carbon intensive. There's nitrous oxide from fertilizers, methane from cows, if that's what you're doing, and manure and fuels from agricultural machinery. So the existing land use is quite intensively carbon emitting. And then you look at the actual project itself, so the construction, the emissions from that, the emissions from the operational phase or the ongoing and this housing development, so kind of the heating and the car use, and then look at, I guess, ways of mitigating that effect, possibly through design, looking at flood risks, and other ways. So that's kind of the greenhouse gas assessment that you include in EIAs. However, on the next slide, talks about the indirect effects, and Neil, the first Neil, mentioned this briefly in relation to the Greenpeace case and the Vorlich case. But I'm looking at Finch, which was a Queen's Bench Division decision, and it's looking at how far does your EIA assessment / greenhouse gas assessment go. So this involved Surrey County Council granting permission to expand an existing oil well and extend its life by 25 years. The environmental assessment had the greenhouse gas emissions for the actual operation of the site itself, but it didn't assess the use of the oil that's going to be extracted downstream by consumers, such as in cars or in housing heating. And the court did put did kind of restrict it, and they said there has to be a limit on how far your assessment goes, basically. And so you need to kind of look at the direct and indirect effects of the development itself. And quite helpfully, although in this case an inevitable consequence of extracting oil is going to be that it's going to be probably burned or converted into kind of petrol to be used in cars. So there's going to be an inevitable consequence of greenhouse gas emissions. They said when the oil left the site, it became an indistinguishable part of the international oil market. So the greenhouse gas emissions generated couldn't be attributed to any particular oil well or site. So that kind of puts a bit of a limit on your EIA assessment and how far as an objector you can kind of go in terms of bringing downstream effects and emissions coming in. But that still doesn't prohibit you from covering or requiring you to recover indirect effects of the development itself, as required by Schedule 4. So that's briefly the content of the EIA. So I'm just going to look at planning challenges, and understandably on the basis that we're looking at climate change and greenhouse gas emissions, the challenges are going to be around EIAs generally. So the first case is the Heathrow case, which I'm sure a lot of you are familiar with. June 2018, the airport NPS was designated by the Secretary of State for the expansion of Heathrow, and particularly the Northwest Runway. Challenges were brought, and the Divisional Court in 2019 dismissed the challenges, but in March 2020, the Court of Appeal allowed the appeals of Friends of the Earth and Plan B Earth They basically said the airport MPS has no legal effect because the Secretary of State acted unlawfully in failing to take into account the UN Paris Agreement on climate change in designating the NPS. Heathrow Airport appealed to the Supreme Court. Actually, the Secretary of State didn't. He didn't decide not to join. And in December 2020, the Supreme Court upheld the appeal and reinstated the NPS. So the basis, I'll go through the conclusion very briefly, but the basis of one of the arguments was that the Paris Agreement was government policy because Andrew Leadsom had made some comments, public comments, saying that the Paris Agreement will be put into UK law, but it hadn't at that point been put into UK law. So there was no net zero target, for example, at the time of the NPS. And so the court confirmed that for government policy, and as Neil, the second Neil mentioned, government policy is kind of fundamental decision making in the planning process. Ratified international treaties, such as the Paris Agreement, aren't government policy until implemented into UK law. The court also mentioned in relation to the strategic environmental assessment and the sustainability appraisal that the Secretary of State had a discretion regarding what information was to be included within a sustainability appraisal. And that the bar was quite high on that. So he said it will only be unlawful if no other reasonable decision maker would come to the same conclusion. And then looking at post-2050 and non-carbon emissions, at the time of the NPS, the relevant policies were still under development. And so the court said the Secretary of State would have had to be irrational to not take such policies into account. So it's set a pretty hard bar in that regards. And as you can see, implications on the slide, basically future infrastructure projects are going to have increased scrutiny because we now have the net zero targets, we have other environmental targets, and it's probably going to be a climate emergency, and it's going to become a bigger thing. And so for example, the Northwest Runway scheme, when it does come to a DCO application, is going to have that great scrutiny because we have these targets now in law. So the next case, thank you very much. So this is Client Earth in relation to the Drax power station in North Yorkshire. So there's a DCO granted to convert or modify a coal-fired generating unit to gas-fired generating units. The Secretary of State approved contrary to recommendation. That recommendation was on the basis of climate change grounds as well. The case looked at interpretation of the Energy NPS, or EN1, and it was alleged that the Secretary of State had misinterpreted it in relation to greenhouse gas emissions. So policy EN1 says that CO2 emissions are not reasons to prohibit the consenting of projects. And the court basically clarified that it doesn't say that the CO2 emissions are irrelevant to development consent decisions, and they're not to be given due weight. Instead, it's saying that CO2 emissions are not of themselves an automatic and insuperable obstacle to consent being given for infrastructure, especially when it's been identified as needed by said policy and there's a presumption in favour of approval. So yeah, it's just kind of saying that it's not a silver bullet saying the CO2 emissions, but they're still an important part in the whole decision-making process. Next slide, please. Thanks. So the next one, slightly different theme, is housing. So Abbots Kerswell Parish Council challenged the Secretary of State's grant of an outline planning permission on approval for quite a big mixed-use scheme which had housing, retail, school and care homes. They alleged that the Secretary of State had been unlawful in granting the permission because they hadn't assessed any material environmental information relating to greenhouse gas emissions and climate change, and they said this is in breach of the EIA regs. The challenge was dismissed by the court, and on the question of assessment of emissions, they said that on the basis that they're supposed to be included under Schedule 4 of the EIA regs, they said the Secretary of State is only required to consider the adequacy of information on climate change as may reasonably be required. So it's quite a, I suppose there's a large degree of discretion for them there, and said they've got a wide range of autonomous judgment on the adequacy of environmental information provided on basis of what was reasonably required. And they must be free to form a reasonable view of its own on the nature and amount of information required. And that's subject only to the review of Wensbury reasonableness, so irrationality. So again, it reinforces there's a high threshold for something to be unlawful when considering the contents and greenhouse gas impacts and assessments. And in this case, to help it, I suppose, was the site itself had been allocated under the local plan for housing. Part of that, and for a mixed-use development, sorry. Part of that was there was a strategic environmental assessment, there was a sustainability appraisal, and they'd considered a lot of the kind of the strategies that needed to be provided and the greenhouse gas emissions. And so as the site was proposed as a highly sustainable site, and it was accorded with the strategy of the LDP and the sustainability appraisal and those principles, that kind of helped to show that the information was adequate on this case. But it does kind of stress that the court's saying that it needs to be a rational, a very high hurdle for it to kind of successfully challenge. And so giving quite a bit of discretion, I suppose, to the decision makers in this in this complex area. And then the final one, which is related to the A38 junction DCO. So this was three major improvements to three junctions on the A38 to try and help congestion. It was ultimately on the balance, the Secretary of State found on the balance that it was the benefits outweighed the climate change impact of construction and subsequent congestion on other roads whilst the construction was going on. And essentially the claim came, or the challenge came, on the basis that the Secretary of State had breached the infrastructure planning EIA regs, had failed to consider cumulative climate change impacts and to provide an up-to-date reasoned conclusion, failed to provide legally adequate reasons in its decision notice, was irrational in its conclusion, failed to consider the net zero target and climate emergency, and it didn't quite get to the full judgment because the Secretary of State conceded that it failed to provide a reasoned conclusion, which is required by Regulation 21 of those regulations, and hadn't included such reasoned conclusions in its decision notice. So it was more, they conceded on the basis of almost a technicality, and Highways England still hold that their ES was competent, it had all the information it was required, and so they're submitting the application on the same basis to hope that they're not adding any further information in. And so I suppose there's an element of a further challenge on the basis that if it does go all the way to DCO on that basis. And that I'll pass back to Neil on that point. Thanks very much.
Yeah. Thanks, George, and great to get a summary there of all those cases, just to see the approaches the courts have been taking. So just to pull the threads together before we look at the questions that have been submitted. The other Neil took us through the emerging trend of strategic litigation against the government, broadening into the international context. The interesting issue about whether actions against corporates such as Shell, if that's likely to become more of a trend, and then myself, George, narrowing it down to planning decisions and looking at the relevance of climate change, how it's part of the information base, for example, in environmental impact assessment, but it's also part of the balancing exercise. So there's no special weight there. And just to turn to some of the questions, and I'll maybe answer a couple of the questions before passing over to Neil and George, because some of them actually pick up on that issue that I just finished on about the balancing exercise. One of the audience was saying what might happen to this balance between planning issues and climate change, given that climate change may have more of a front row position in the forthcoming Scottish Government National Planning Framework. And that is an issue we just wait to see with interest, because inevitably some stakeholders are pushing for planning to be given much more of a specific role in addressing the climate emergency, and saying that the Scottish Government need to do something to change the balancing exercise, to make sure that it's not left on such a individual site-specific basis, project-specific basis, decision-specific basis, and there's more an imperative. So it's really, I suppose, whether Scottish Government feel it would be appropriate to fundamentally change the balance and weigh it much more in favour of the importance of the climate emergency, or leave it so that a bit more emphasis is given, but it's still inherently a balancing type situation. So that's very much going to be an interesting one to look out for. And again, just to address another one of the questions that came in, and someone was asking more from the other side and saying if there's a stakeholder that is a bit anxious that the policy commitments, the move, is all a bit ambitious and might be wanting some lower standards or some longer transition periods. What sort of issues should that sort of stakeholder be flagging up to Scottish Government? And again, that really touches on the balancing exercise of looking, saying, as things stand at the moment, economic imperatives need to be taken into account as well, and whether Scottish Government might want to continue to give a reasonable balance between economic interests, climate emergency, and not adjust that balance just too far in the direction of the climate emergency. So there's very interesting arguments in that policy context that we're all aware of that are going on, and the legal implications of that sort of policy debate is when it flows through into the court cases. And the other Neil mentioned, in fact, George did too, the Greenpeace case in the Court of Session. It's going to be very interesting to see the outcome of that case, whether the court takes a similar line to the cases that George was mentioning, and the more sort of traditional approach, which is really the law is not going to get involved in how the balance is struck, as long as it's not irrational or perverse. The right things have been taken into account. The judges are just going to say, well, it's up to the decision maker. But Neil, one of the questions that did come out was there's always been a concern about the cost of litigation and environmental litigation being prohibitively expensive, and there's Aarhus Convention issues around that. Don't worry, I'm not going to ask you to explain the Aarhus Convention issues, but the question was really, given the expense of litigation, why are we seeing this rise in the number of challenges that are being brought by environmental campaigners?
So it is one of the more surprising things that have happened in the last few years, is the ability of individuals and NGOs to raise litigation, including to fund proceedings all the way to the Supreme Court. And there are a number of factors as to why that's been possible. The first is really that crowdfunding has become a lot easier and a lot more sophisticated, and people are used to using those platforms, and they're able to raise quite substantial sums of money quickly in order to fund litigation. There are also in the private sector challenges that we see different funding options available, particularly where damages are sought. So there can actions of nuisance against private companies. You might get a situation where a litigation funder steps in to take some of the risk. And the final thing I would probably say is that, absent getting a sort of protective expenses order in Scotland or a protective costs order in England, there is a reputational issue for the organisations defending these challenges, and the perception of, even if you win, being seen to recover all of your costs from the other side in the way that you normally would. So those are things that people are thinking about as well, is that really just how does it look, to try and recover hundreds of thousands of pounds from an NGO or from individuals in the event you've succeeded in litigation. That's not to say that it's not appropriate to do that, and it might be in some cases, but it's all in the mix in these sorts of challenges.
Returning to the questions, there's a very interesting one here about environmental impact assessment. And George, I know you touched on EIA, but equally I know Neil knows about it. So you both might want to have a think about this one. I think it is very much one of these questions, there isn't a right answer. It is really just something that's interesting to discuss through. The question was, given that the climate change receptor is the global climate, does any individual project ever have a significant effect on it in EIA terms? And then in the alternative, is every incremental effect contributing to a significant cumulative effect? Which would mean that every development with any climate change impact requires EIA. So I think it's quite interesting. It's just maybe a bit more abstract, because certainly in terms of requiring EIA, probably projects would require EIA for other reasons, not necessarily the climate change ones. That's perhaps a little bit more academic. But any thoughts on those questions? I don't know, maybe it's hard enough. Do you want me to read them again?
My background is geography, and I did a lot of climatology at university, so I don't want to get too geeky and go into talking about attribution. But I do find it difficult. I think there was a case a few years ago, which is a Brazilian case, which I can't remember the details, but essentially they managed to get compensation for a percentage of the damage that they received because of flooding or some climate change related impact, and they got a percentage of the damage caused from a local plant on the basis that it contributed X% of emissions. And I've found that quite difficult to understand on the basis that, again, not trying to be too geeky, but CO2, once it's emitted, spreads and it goes evenly across the atmosphere. Methane, on the other hand, is a lot more localized, so it's slightly easier to say something that emits methane will have more localized effects, whereas CO2, and that breaks down quicker, whereas CO2, once you emit it, it then spreads across the whole atmosphere. And so it is hard to say why one project can contribute X% of a damage caused, unless you just look at you've contributed X% of all emissions of CO2, therefore your contribution is Y. But it is a hard one on the basis that, in theory, every project that emits CO2 on an incremental level will have a climate change impact, unless it's captured, I suppose, but any emission to the atmosphere. So yeah, it's I guess an EIA will never be able to fully grasp the impact of a specific quantum of greenhouse gas emissions, but to pin it down to the emissions of one project causing a certain impact across the world is quite hard, and even locally it's quite hard to kind of pin down. But yeah, without going into too much of the science behind it, that's my answer.
That's really interesting, and one of the recent challenges that's been brought against a private company again is in Brazil in relation to deforestation of the Amazon between the years 2011 and 2018, and there's an action being brought against a cattle farmer. And I suppose in a private law action, the court can fall back on how it assesses damages by looking at remoteness and whether, in fact, the damage caused the loss suffered to the individual or individuals bringing the claim. But I would agree it's much more difficult to do that in an EIA context, and I think that's probably what we'll see in the Vorlich case. Obviously very dangerous as a litigation lawyer to make predictions, but I would be surprised if we see anything other than a decision which is consistent with Finch, and can fall back in the established principle that you have to draw the line at some point, and the sort of indirect effects in Vorlich are too remote from what needs to be assessed as part of EIA. But I may be wrong about that. We'll just have to wait and see, and that'll be one of the interesting things.
And I think for me, what both of you were saying in response to that question, what it flags up is the environmental impact assessment process is information gathering and then making an assessment, but it is only a tool in the wider decision-making process. So it's what the decision maker then uses that information for, but also I think it goes back to one of the overall themes for today's session, that arguably to make effective change, it requires governments to enact legislation which addresses some of the difficulties we've touched on. For instance, going back to George's point about some of the greenhouse gases, because of the way they disperse, it's difficult to measure the impact. If government tells us that each project has a target of X, then that's something that we can assess, because we know that government has mandated that's the target. If government tells us acceptable levels, we're used to, for instance, with noise, there are a whole series of understood thresholds, guidelines. We can use those in making decisions. So in part, it's for government and statutory agencies to bring forward that sort of information so that decision makers have something to then use as a benchmark, rather than, as George was saying, with some of these greenhouse gases, it's yes, we know incrementally there is a change, but it possibly being difficult to take account of that in individual decisions. So it's quite interesting. I think that brings together a lot of the threads we've touched on, and particularly taking it back to just that overall theme of climate litigation and the difficulties that are inherent within the decision-making process, where the courts may well say, it's not really our job as the court to resolve this. It's an issue for Parliament in legislating to fix it, which has very much been a traditional approach. So I'll finish it up there. Fantastically on time for once. Very impressed. So to say thank you to Neil and George for their contributions, to the rest of the Brody's team for helping us out. Thank you to those of the audience who gave us those interesting questions to answer. Just a brief advertisement. We're running a climate change webinar specifically focusing on local government later in the year. There is information available on that on our website, as indeed there are for all of our webinars. Encourage you to look at that and to book up. But particularly any of you in the local government sphere or particularly interested in planning decision making, although we will be covering some of the same ground as we did today, we'll very much be giving it that local government focus. Should be very much of interest to any of your colleagues in the local government sector, or as I say, people particularly involved in planning. So thank you all again, and I hope you have a productive rest of the day. Thanks very much.